Good afternoon, and thank you for joining us for CSBA's Legal Update webcast. This is our third episode of the fourth season. I'm Keith Bray, General Counsel at CSBA and Director of its Education Legal Alliance. In this series, we bring you top attorneys in the state to weigh in on issues you could be facing at your district or county office of education. If you can't stay with us for the full hour, we'll have the recorded webcasts available at our homepage by Friday at csba.org. Today we have assembled a distinguished panel of attorneys to discuss charter schools and what you can do as a school board member to increase accountability during the petition review process, and how to oversee charter schools to ensure a meaningful education is provided to each and every student. First, I'd like to introduce our panelists. We're glad to have back with us today Sue Ann Semin-Evans, attorney at Dennis Walliver Kelly's office in Long Beach. Welcome, Sue Ann.
Thank you.
She has been representing school districts on charter school matters since the early years of the Charter Schools Act and is called upon often as a leading expert in charter school matters. She has handled numerous charter petition reviews, renewals, and revocations, and successfully defended a school board's decision to revoke on an appeal to the State Board of Education. We're also fortunate to have with us this afternoon Ed Sklar, an attorney with Lozano Smith's Walnut Creek office. Welcome, Ed.
Good to be here.
Ed serves as co-chair of the firm's charter school practice group. His practice involves all aspects of public school districts' obligation to comply with California Charter Schools Act, including charter oversight, facilities, petition review and revocation, and the establishment of dependent charter schools. Welcome both of you to our discussion this afternoon. So, charter schools. They're here. The Charter Schools Act was initially passed in 1992. We have over 1,230 charter schools in California. 10% of the population of students in this state go to our charter schools. So they're with us. When charter schools are open to accountability to the public and to providing meaningful education to all students, they have really become an indispensable part of our public education system. School boards often delegate their authority to the superintendent and to her staff. With charter schools, they become quite autonomous because the law provides for that. So today we're going to talk of a couple of examples of charter schools that have kind of gotten off the beaten path a little bit. Charter schools that are corporate in their nature and corporate in their structure. We're going to spend some time with both Sue Ann and Ed to do so. I really want you all to pay attention to these examples. CSBA and other enlightened organizations have spent years, perhaps a decade, trying to get the basic principles of governance applied to charter schools. That would be open meetings, conflict of interest laws and regulations, and being accessible to the public for the information that they produce. I think the examples that we're going to talk about today will show why that is necessary as part of a public education system to have charter schools playing under the same rules that we as school boards and county boards of education operate. So I'm going to introduce Ed and Sue Ann, who are going to tell the stories of a couple of charter schools that have been noteworthy and newsworthy at the same time. And to give you all an understanding of how a corporate structure works. We're not going to get into the elements of the Brown Act or the elements of open meetings or conflict of interest laws. You can access those on other webcasts that we have on our website at csba.org. You can access our Charter Schools book, which is a guide for governance teams if you want to know more about the ins and outs. we're going to get into what charter schools, what they can do basically to avoid the oversight. We're going to talk about better oversight practices, what you can do at the petition stage, what you can do with respect to renewals and revocation. We're going to get into all that. So to best do that, I'm going to turn now to Ed to introduce for us the topic of how Oxford Prep has set up and has been under some of the accounting practices of FCMAT.
Sure. And I believe we have a slide on Oxford Prep. Oxford Prep became the prototype of concerns raised that we see in charter schools when they've been formed. Oxford Prep formed itself, Oxford Preparatory Academy formed itself as a standard charter school back in about 2010. It was chartered by Chino Valley Unified. From there, Oxford Prep Academy opened up a few other schools, a few schools in Chino Valley, a couple more schools in Chino Valley, some schools in Capistrano Unified, and another school in Borrego Springs. In creating the further charters, another nonprofit was created, another nonprofit corporation, the Academies of Oxford Prep. And you'll see these on the slide, known as OPA and TOAP. They were basically the first-line nonprofit corporations that oversaw or managed the daily operations of the various charter schools that Oxford Prep had opened. In about 2012, these corporations created, and the founder of Oxford Prep created another nonprofit corporation known as Oxford Prep Academy, or OPAS, as you'll see on the slide. That's at what I'll call the top of the food chain. They eventually, OPAS became known as Ed-Lighten Learning Solutions. Ed-Lighten Learning Solutions became the CMO, the charter management organization for the various charter schools at the bottom of that pyramid, and they were basically performing the back office services and the administrative services for Oxford Prep Academy and the Academies of Oxford Prep. And remember, all of these nonprofit corporations were created by the same founder.
So we have a corporate structure that shows almost a pyramid effect. Why don't we go to celerity real quick with Sue Ann, and we'll put that structure on the screen, and you can see how that pyramid shakes out.
Okay. Well, it's a lot to look at when you look at that organizational chart. Celerity actually started in about 2005. There was a woman named Vielka McFarland, and she wanted to create celerity education. Went to LAUSD as the authorizer and started establishing schools. There are about 6 celerity schools within LAUSD boundaries that were approved by LAUSD. Just to note, the slide actually refers to ACME, but this is our best reflection of based on our investigation and a lot of digging to see what celerity actually looks like now. In about 2010, they were renewed. Several of the schools were renewed, and then about 2011, 2012, about the same time frame as Ed was talking about, the district noticed through their oversight that there was a company called Global, Celerity Global. And at that time, they didn't know what it was and started to reach out to the charter school to understand the role of Global. As it turns out, Global, the way the charter explained it, that Global is a separate entity. It's not subject to the district's oversight, in effect, and that the documents and other information they were looking for was just beyond the scope of what they were going to provide to the district. The district, kept looking into it, kept trying to develop information, and what they ultimately have been able to find without great assistance from the charter operators was that Global had become the sole statutory member of the charter school board. And what that means is that as the sole statutory member, they had the authority to decide who was going to be on the board of the charter school, who would be removed. So they had direct control over that charter board, but again, outside the scope of the oversight of the district. They were also a vendor to the district. And again, digging more and more, which is not an easy thing to, this information is not easy to get. What was learned is that they have contracted with the charter school group to basically transfer funds, provide services that were the same services that were being provided by the charter school board. And we learned that Vielka McFarland was involved with each of these corporations. So we have Celerity, Global, Celerity Education, Celerity Contracting Services, and on and on. So in 2015, the district the board declined to renew the charters. I was going to note, there's kind of an interesting timeline after that. They appealed that ruling or decision and went up to the LA County Office of Education, who also declined to renew them. It went before the ACCS, the Advisory Commission on Charter Schools, for their recommendation to the State Board of Education. And they recommend that the State Board approve the charter with some conditions related to how they're going to be more transparent. But then in January, going back to the headline, the feds raided, and it was pretty incredible what they did. They raided the offices. They also went to Miss McFarland's home, and apparently guns were drawn. I mean, this was a very big deal. U.S. Department of Education, Homeland Security, Secret Service, FBI, Immigration, LAUSD, Office of General Counsel, or of Inspector General, all involved. So it was, it made a lot of headlines.
So as we look at both of these charts, does it beg the question, who's in charge?
Absolutely.
It really does, and I think that there are, between the Oxford Prep and the Celerity issues, in regard to who's in charge, there's three things that are really tying these, the various corporations, all started by the same folks, together. There is the larger, what I'll call the mothership, serves as the CMO, the Charter Management Organization, for the nonprofits below it that directly operate the charter schools, as well as what Sue-Ann was talking about before with the sole statutory memberships. That's what allows the mothership, so to speak, to control the nonprofit corporations below it.
And specifically, how does a sole statutory member do that in California?
Sure. So the sole statutory member is basically, as Sue-Ann said, it's put into the bylaws that sole statutory member, A, is allowed to dismiss all directors on the Board of Governance, has that authority, and as well as, in certain circumstances, disposing of the assets of or determining the disposition of the assets of the nonprofit corporation if it dissolves and in other instances. So it gives it a lot of power. Basically, they get to, that sole statutory member, and in this case it's the corporation above the nonprofit that's directly operating the charter school, it gives them an opportunity basically to remove directors at will.
And isn't that really contrary as to how we think of nonprofit corporations? When we think of either charitable purposes or purposes that the corporations operate for the social welfare, do we think of it being one person controlling several corporations, or do we really think that those corporations have their own independent boards?
We are really seeing, in the way that they are written in most charter petitions, is that there is a board of directors who are independent and are not controlled by anybody. In fact, I think the pattern you would see in most of these charter petitions where this happens is, once the charter petition is granted, then the bylaws of the corporation are amended to bring in the sole statutory membership.
And we're going to get to that with our talk about oversight in terms of that's one of the factors that boards should look at, school boards should look at. But what about the membership of these corporations? Are they all independent, autonomous people that are brought in because of their of their success in their own business or social or family life, or do they happen to be some of the same people?
They happen to be some of the same people, and interestingly, they're doing things beyond education. For example, they'll set up a corporation to develop property, or set up a corporation to provide administrative services that really the governing board of the charter school should be providing. So that's where that sort of double expenditure happens. You're paying the funding into the charter school's using it for administrative services, but passing it on, passing additional funds on for administrative services as well. So we're talking millions of dollars that, I think I used the term earlier, funneled up. That's what we're seeing. And out of that, I might add, we're seeing huge executive salaries. Via McFarland's salary was something like $500,000. So these are, and that was just for one of the corporations.
So I think when we look at, for example, the Acme Charter School chart, and we see more than one CMO,
Right.
we see layers upon layers before you actually get to the school site. What possibly can, and we see out-of-state corporations involved. What happens to, how does that funded? How is that supported?
Well, what we're seeing is, for example, with Acme, the authorizer, if you look to the left of the slide, there's showing 6 schools authorized by a district under Acme Educational Group. And that's what the authorizer believes their charter is. They have a CMO that operates 6 schools, and they're the authorizer of all of these schools. And so they believe, from the information they have, that that's what they're responsible for authorizing. But when you, again, pull back and look at the whole picture, you see that that there are multiple corporations. And what is happening is they call them different things, like intercompany loans, payables and receivables. And what that really is sending money out to other organizations, for purposes of either developing or funding other schools. So in this example, you see that Acme Schools Louisiana. There's Acme Florida Group, where we see money actually going out of state to fund schools outside of California, our public funds.
So back to the Oxford Prep example, this started in Chino Valley,
Correct.
San Bernardino County. Where did it then go, Ed?
Well, it then it went to Capistrano. It went to Borrega Springs Unified.
Both different counties.
Different counties, and so they opened up this, as I mentioned before, they opened up this second nonprofit corporation, the Academies of Oxford Prep. That's at the other second line. And then you would have Oxford Preparatory Academy Schools at the top of the food chain, who is the CMO for both of those nonprofits, OPA and TAOAP. The bottom line, and to cut to the gist of it, is all of these companies, once you moved up past the individual charter schools, all of the companies above it were basically performing the same functions. And so there was this overlap. So you had 3 corporations doing the job of one corporation. And what we were seeing was you had this overlap of employees. It was the same employees in the same facilities doing the same duties. But they were all getting paid.
They're hitting that revenue stream
Correct.
with whatever percentage they're taking out 3 times.
That's right.
That's correct. And one of the things that's not noted in this Oxford Prep chart is that, in fact, there were 2 other, the FICMAT report that was done, there was an extraordinary audit that was done called by the Superintendent of County Schools for San Bernardino. What was discovered was splitting off from Oxford Prep, Preparatory Academy Schools at the top, there were 2 other private for-profit corporations that were also doing overlapping duties, that were also getting paid by OPES. So you had 5 corporations that were getting paid to do the same thing. And so you would literally see, when we talk about the same employees, you would literally see very confusing contracts that would be leasing employees from one corporation to another corporation, so to perform the same functions, basically sitting in the same office. But once again, everybody was getting paid.
And let's just talk a moment about the extraordinary audit, FCMAT, that comes in upon the request of the county superintendent, in this case San Bernardino County, to really audit and to ask the questions that the county office has been asking but not getting answers to under their AB 1200 powers. We know the Public Records Act requests don't work, so we use AB 1200. How successful was FCMAT in getting the information that was necessary to really figure out what was going on here?
ELS, Enlightened Learning Solutions, in this specific instance, refused to cooperate with FCMAT, refused to provide any documentation saying that they were beyond the jurisdiction of that extraordinary audit. They basically said this county superintendent has the ability to request an audit for the schools within, and for the charter schools and the districts within his or her jurisdiction. We're beyond that jurisdiction. We will not cooperate with FCMAT.
So we had a charter school that was opened up in Orange County and one that was also up in San Diego County. Using that same logic, there would have to be 3 separate audits by FCMAT in order to exert.
And that's the experience that we've had, exactly, where we've gone to FCMAT and they've said, look, or to the county, and they said, this goes beyond our jurisdiction. We can handle this county, but we can't tread into San Diego County. So you're not getting the full picture. And to Ed's point, a lot of what FCMAT is getting is what the charter school is willing to provide. It's not like they have subpoena power or things to really get behind. They've done an amazing job gathering stuff to put the picture together, the puzzle together. But I just would add that districts, if districts are expected to do that kind of investigation to meet its oversight responsibilities, that's just far beyond what I think any district could afford to do.
Well, in following up with that, I'm going to put the Acme Charter Schools slide back up. And that begs that question again. Who's hiring the audit firm? Who's hiring the CPA? Who's hiring the attorneys? Who's controlling the bank account? If you looked at the chart, where's the answer to those questions? It's hard to see, right?
That's right.
And so how are districts or FCMAT or any other outside entity able to really research and inquire so we can see that the money that is given to charter schools, allocated to charter schools, the public dollars, are then spent on the students at those school sites?
Right. And FCMAT in the Oxford Prep report investigation did note specifically that that they did not have this that they had this lack of cooperation, and that they basically were that there was an attempt by Oxford Prep to not only funnel money to the corporations of the founder, but also to try and preclude transparency for the money and for those transactions.
Well, and even adding either other vendors, out-of-state vendors, adding other CMOs. I mean, in the Oxford Prep example, Epic Charter Schools came in to help run those 3 schools, right? And one of those schools is in Orange County. Now, Epic is, and the schools that it's opened, the online charter school that it's opened in Orange County by the Orange County Office of Education, that's being challenged by the Anaheim school districts because of that impact. We should probably get into that a little later when we talk about geographic limitations and especially issues of online charters. But when we look at these examples, and we're going to get into that, what can districts do? Let me go right to our oversight. What are districts going to be able to do to figure out who's in charge, to figure out really what the plan is, where they're already operating, what their intention to operate is? What can we start doing?
Well, first we can start to identify things to look for. I think we've been a little bit playing catch up to this structure that has become popular with charter schools. And so developing what the oversight concerns are helps us understand how to deal with them a bit better. We have a slide on oversight concerns, and it's the things we've talked about: transfer of funds to entities that are not part of the charter or approved by the authorizer, these governance structures that have a lot of tentacles.
And isn't that the key? We follow the money.
Right.
Because if you can have, if you're noticed of that, you can then bring questions about that. You know how the structure is being set up.
That's right.
If you know how the structures are going to be financed and who's involved in that finance.
That's right.
That's correct. And what we had mentioned before was the fact that all of these changes in the governance happened after the petition had been approved. And so it was sort of an after the fact. Literally within months of the petition's approval, there would be amendments to the bylaws, including these sole statutory memberships, and having all of these setups that are precluding transparency.
And that goes to the second bullet on the screen, right? I mean, there's the permissibility of these structures being created. And the governance structures, we've talked about the sole statutory membership and the power that would be included in those, right?
Well, I'm not sure I agree that there is that kind of permissive authority to have these structures. We've talked about the problems they create, but when we are thinking about the Charter Schools Act, I'm sure if you spoke to folks that were around when the Charter Schools Act was put into place, they would not have thought that there would be 5 corporations tied to the charter school. A board and a school, and the fund goes to the school. But the other piece of it, when we've had litigation over charter-related issues, the courts have said, including the CSBA versus State Board of Education case, that oversight is the key to constitutionality of the Charter Schools Act and to keeping those schools operating legally. And if you are overtly trying to avoid the oversight, either by not cooperating with it or by creating these entities that are outside the jurisdiction, as they've said, then you are undermining that very key point to charter schools being in existence at all. Absolutely.
And the legislature had an opportunity at least to begin reeling this in a little bit.
Right.
Bill was passed and the governor vetoed, which would have prohibited for-profit charters from operating in California as of 2017. He vetoed that bill, said we really don't have the evidence now of why for-profit charter schools are basically bringing in, tearing the fabric of our charter school system, right? But corporations have been around since, what, 18 or 19 years in terms of they've been permitted to run charter schools, nonprofit corporations.
Nonprofits.
And is there anything in corporate law that really prohibits, this structure that we've had, the proliferation of different corporations to manage and run charter schools?
Well, there are conflict of interest laws. There are both the public entity conflict of interest laws that we all are bound by in our school districts. And then we have the corporations bylaws that are, or not bylaws, laws that are less strict, I guess, than the public entity because of the public funds that are involved. That said, there are still some requirements that they comply with, and that's not to have self-interest and to take certain steps if a contract or other financially, something that you're financially interested comes before you as a nonprofit board member. But those things, and it's a big fight, frankly, in the charter world between whether the public entity conflict of interest laws apply or they're limited to just the corporate laws. And I'll just finish by saying that, we're dealing with public funds. There's a reason why conflict of interest laws were put in place to protect those public funds. And we're seeing, by having this sort of freedom and to create these kinds of structures, we're seeing the consequences of that. And I think what really reinforces the notion that things like Government 1090, Fair Political Practices Act need to be used for accountability.
And I would say that the Fair Political Practice Commission has been very consistent that charter schools are supposed to be covered under the Political Reform Act. For the most part, in charter petitions, you will see charter schools conceding that. But I think the real fight is twofold. One is under Government Code Section 1090.
Right.
And then in regard to when we're creating all of these corporations, these nonprofit corporations, which ones are covered by the Political Reform Act. So I'm sure that Oxford Prep would say that Enlightened Learning Solutions is not covered, and those board members are not covered under the Political Reform Act, and definitely not covered under Government Code Section 1090.
And remember that 1090 has the prohibition. If you're self-dealing or there's a contract that a member of a school board is involved in, then the board can't take, and with certain exceptions, the board can't take action and approve that contract, or the contract becomes void. In the corporate world, it's more of it's a recusal situation. Right. It's a disclosure to your fellow board members, but then you just go forward. And with the examples that we've brought up today, where the corporations are being formed and basically, being staffed and managed and directed by the same folks. Our last slide there, our last bullet on this slide talks about the executive compensation, and how does it get so high? Mm-hmm.
What we've seen is that, if we look at the ACME slide, you have all of these schools. There's a whole litany of schools, and they kind of go up to the pyramid structure that I think, Keith, you used the term for. And a little bit from each school goes up, 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 and it adds up to, like I said, half a million dollars for the Celerity CEO.
So now we're going to go to, those are the examples. One brought to us by a very credible report by FICMAT. The other brought to us through the world of petition approval and appeal eventually how it got to the State Board of Education. And those are the examples that really set the foundation, I think, as to, okay, so really what, on any petition that comes before a charter school board, what should board members be doing? What should they be looking at? And why don't you all take a run at this with the petition process before the school is approved?
Sure. Well, just every charter school petition is supposed to have a comprehensive discussion of what its governance structure looks like, and so in moving forward, when you have a charter petition in front of you, there obviously should be that discussion, an accurate discussion of not only what the government structure is going to look like on day one, but also what's it going to look like 2 months, 2 years down the road. And if there is a change in the governance structure, then that certainly should be what's known as a material amendment to the charter petition coming to the board, to the authorizing board for review, so that there's full disclosure.
So let's talk about that, because I think that's one of the most underused leverage points in the law. A material revision, what happens? What's that process?
The process is the same process that you use for an original petition. Anything that is a material change, what does that mean? Substantive, it has an impact on the elements of the charter school. I think in my mind it's very clear that a change to governance is a material change to the charter, because governance is one of the key elements. So the process is that it's to be submitted to the district, the board has a public hearing on it, just like you do with a petition, and then a decision on whether to grant that material revision.
So here we go. It's through that petitioning process. It's the board making it clear that, hey, if you're now going to go out and no longer operate the school, but hire a charter management organization to come in and operate the school, that would be a material revision. Or if you already have a CMO and you then hire another one, that's a material revision.
Or if your board of directors is going to be controlled by a sole statutory membership, then that certainly is a substantive amendment.
Yeah. So, by the way, the slides that we have that are kind of listing out what we think are really good practices, they will be available for you along with the video from this afternoon's session. Let's talk about other.
One of the things that, petition review, the statute hasn't changed a whole lot, but the process that we go through has to change. You have to be thinking about all these developments in charter schools to really understand what you're getting when you get a charter in your district. So that includes asking, about CMO agreements. Do you have a CMO? Are you connected with other charter schools? Do you have other authorizers? It hasn't always been. Some districts and county offices do an intake meeting with the charter petitioner to gather information. I don't know a lot of districts that do that, but it might be a good place to start now, because this is the kind of information that isn't called for in the petition itself necessarily. And speaking of that, the nonprofit bylaws are absolutely critical to look at, and they should be attached to the charter petition as a key component of the governance portion of the petition.
And I think it's a very good idea for charter authorizers to have school districts to have up front in their written policies or as an exhibit to their policies exactly what they expect to see in every charter petition that's submitted to them. I think that that's a good process to have. So for everything that Sue Ann was just talking about in regard to you're supposed to, when you submit a charter petition, submit the bylaws of the corporation. You're supposed to submit a chart, a pyramid chart as to exactly what your governance structure looks like, whether you're run by a CMO, and then any business relationships or affiliated corporations that the CMO has.
So we want to know where they're going to locate.
Correct.
They have to
right.
declare so in their petition. We know that successful schools, or maybe less than successful schools, will expand and locate elsewhere, even if they're authorized elsewhere. Shouldn't we include that as part of our petition process? That we want to know that?
It can be part of the petition, but there can also be a memorandum of understanding where we can dive down to some of those details in a contract with the charter school. And we can talk about some of
Sure.
the key provisions. But with the charter petition, I know on our slide we have indemnification. I strongly encourage all authorizers that are interested in approving a charter school to ensure that the indemnification provision is solid, because there is a lot of challenge going on with charter schools, whether it's locations or these kinds of structures, and having that protection in place is important. Also, because an oversight agent can be liable if they have not met their oversight obligations, and when we're seeing this kind of structure set up, it's of course very difficult to meet those obligations. So that indemnification might be able to help you with a challenge there as well.
When a board member is considering approving a petition, they're focusing on what that charter school is going to do in the district.
Right.
Not only with the knowledge that there'll be students residing in the district that are going to go to the charter school, but outside of the district as well. That's the thought process generally, right? Mm-hmm. What about charter schools that they begin then to open other charter schools that are already authorized but don't ever open those charter schools, or close charter schools? Is this important information, whether it's in the MOU or at the petition stage? Is this important information for our boards to start asking those that are bringing the petitions forward?
It's critical, and I can give an example of a charter school that expanded, and the authorizer of one of the schools was not aware and wasn't getting audit reports, ultimately got audit reports 2 years after, also got a FCMAT report from another district that indicated that the charter school that they had authorized was actually all over the state. And the concerning piece is where the other operations have failed and who's left standing. Is it the charter that you've authorized, and all of that debt that has come out of the failed operations in other places can come home to roost in the charter that you've authorized? So.
Don't forget that one of the legal bases to deny a charter petition is whether they're likely to successfully
Right.
implement their program.
Right.
So it is completely relevant to ask about current programs and prior programs that this petitioner that comes to your district may have operated, because you need to see, are they able to operate other programs? Have other programs been closed? It is right on task and very relevant.
Absolutely.
Yes.
So with the previous example with Oxford Prep, where charter school was opened, in San Bernardino County, then in Orange County, and San Diego County. San Diego County would, and the board there would be able to say, okay, how well did you do in, how well are you doing in Orange County? How well are you doing in San Bernardino County? Graduation rates. What else should they dive into to really get a handle on what this charter is going to be delivering?
Oxford Prep is a really interesting example because they are very well known for very high academic performance. And I have a sense that felt like a protection somehow. If you were just looking at how you're doing, graduation rates, academic score, CASP things, you wouldn't see the issues. And in fact, it took FCMAT to pull that together to actually let the folks know that we're authorizing the charters what was happening. So, and Celerity is not different, and they had good academics as well, at least in the later part of their operations. And we have in the Charter Schools Act that says we're supposed to consider academic performance as the most important factor, both when we're thinking about renewal and when we're thinking about revocation, or that's the starting point. So
exactly.
how do we balance that?
There'll be some schools that academic, and this is, I think, what happened in Orange County with the EPIC charter schools, that there were some issues on their academic performance. But fiscal solvency is also an important feature of making sure that the charter is has a sound approach, right? And if you then look at this pyramid scheme, if you're the last charter that's been open, and you see charter schools that are nationwide or in our state, those questions that board members then can ask at the petition stage, don't they become a little bit more probative with respect to, okay, you've got all this going on and it all seems to be running by the same folks. How are you now going to spend that $7,000 or $8,000 per student on the students that are going to be educated by the school in our district?
That's correct, and that's an open issue right now in the state in regard to whether the money that goes to that specific charter school, whether that can be funneled to other schools within the CMO. So it's very important to ask up front what the policies and the expectations are for the individual charter school that's coming, as to whether the dollars that are coming to those students who enroll in that school are actually going to be used for the students at that school, as opposed to shuffled around the CMO. And
even more important now that we have LCAP and we have money coming to school sites based on their demographic to serve particular students. If that's just getting shuffled around, we lose the whole impact of LCAP.
That's a great point. I mean, here we've got the different grants that come in, based upon the characteristics of the student body, right? The unduplicated pupil count. If the organization is getting it in some places, but not spending it in the place where it needs to spend, and that's what eventually that's what the LCAP would drive. How involved are school districts in the creation and the development and the production of these LCAPs that charters are putting together? How involved?
They're not involved.
Not so much.
Yeah, right.
Not so
We
much.
get a copy.
We get a copy.
Thank you so much.
Which is good in a way, in that it lessens the oversight obligations, but at
Right.
the same time, the very essence of the school program is not within the purview of oversight by the charter authorizer.
So before we go to the MOU stage, which can or be immediately connected to charter approval or not, what about the board? And the makeup of the board. What can we do at that review stage? And about executive compensation, what can we do?
In the review stage, absolutely make sure that you know who those board members are and do due diligence. We work with districts to really dig in and find out who folks are that are going to serve on the board. As we know, they're not elected. We look at the bylaws to see how those board members change seats, how they become either ousted or remain, and that's a big part of evaluating whether it's a board that will be sustainable.
That's correct. And it's also important for the charter authorizer to review these bylaws, because sometimes when I've seen where there are poorly written bylaws and there's a governance or a rift in the governance of the charter school, sometimes the charter school looks to the charter authorizer to help them solve the situation. And so they don't, so charter schools and nonprofits don't like so much oversight, don't like the districts to play a role in the day-to-day operations, but when something's amiss, one of those sides is going to run to the charter authorizer to clean it up.
And shouldn't we be using, going to our second to last bullet there, actually, there's not the bullet, it's my notes, about executive compensation or any compensation.
Yeah,
We've got Transparent California, we've got the state controller, all of whom are putting together, they have on their websites all the salaries, all the compensation, including health benefits and the like, in a school district. Shouldn't that also be applied during the petitioning process to require that of our charter operators?
I would say so, and you look to the budget, right? The budget comes, they have to provide a 3-year budget with the petition. So you look at that to see what compensation looks like. What becomes more difficult in actually knowing what compensation will be is the piece that's, again, outside the petition. We're looking at the additional corporations that money will go to, and will there be compensation from that corporation and compensation from that corporation. So you can address it by asking for the information about how they're going to be governed that way,
So you
and maybe even put a cap on it. But it's that you run into that same problem, that your reach only goes so far.
Yes, and if you're going to have, when is your strongest reach? When is that? When does an authorizer have the greatest leverage?
Prior to the petition's approval.
Right. And so that's why we've spent, I think, a majority of our webcast this afternoon on that stage, because when they're coming in, full disclosure when they come in, as you're reviewing the petition under the laws, but then setting up, right, what might happen in the future, and to be informed about what might happen in the future. And I think, Sue Ann, you referred to that. Both of you all have, I'm sure, have been involved in negotiating several of these, the Memorandum of Understanding. Why don't you help our board members, see, how that might be separate from, or is it necessarily separate from, the petition approval process?
Ideally, you'd like it to be hand in hand, and that it's going on at the same time. But there's two things going on. One is, if you see a petition that district staff and legal counsel, they know there's going to be a recommendation not to approve that charter petition, it almost seems like it's self-defeating to spend your time negotiating an MOU, right? But you're right, that's when you have the most leverage. So it's these difficult waters to navigate. And so, an MOU, that is when you have the most leverage, that is when you should use it. And also, not only just a standard template MOU, but also as you're reviewing the charter petition, if there are difficulties or inadequacies in the charter petition, to integrate and try and remedy those inadequacies into the operational MOU.
Mm-hmm. And with the MOU, I do agree that at the time that the petition comes before the board is the time that you have the leverage to actually get an MOU signed, because charters do resist that. It's more requirements. One thing that we do is make sure to incorporate the MOU into the charter, so that if there's a violation of the MOU, you can treat that as a revocable offense. And having the MOU lay out the concerns you're anticipating. Some of the things we've talked about is clarifying if there are rights to transfer money, under what circumstances would the authorizer allow that to happen, and what information needs to be provided. We have, typically in our MOUs, we include a maximum. If you're going to spend more than X dollars or transfer more than X dollars, then you need to let us know about that. I will say that in the Oxford Prep example, there was an MOU that did require them to give this kind of information to the authorizer, and they declined to do it. So, you can only do so much. But
right, so then what is the response by the local board?
But at least in that situation, once you do find out, you have the ability to take some action. It's very frustrating when you have something like this corporate structure going on and don't know how to use it. or how to apply it in a situation to take action and hold the charter accountable. Is it a revocable offense? Is it a violation of law? Is it fiscal mismanagement? It may be those things.
And hopefully, if there are violations of the MOU that you're discovering over the term of the charter, you're remembering these things at the time when they're up for renewal.
Renewal,
right?
yes.
And well, let's talk about that. So the renewal is typically a 60-day process, thereabouts, depending upon continuing. Is that when you start after having let's say it's the initial charter? And it just make it clear to everybody that the initial charter can be approved for up to 5 years. It doesn't, unlike a renewal, which gets 5 years. When do you start looking at that information? When, right before it's time to renew?
Day one of operation.
Okay.
Because too many times we see districts that are concerned about whether the charter petition should be renewed or not about the 60 days prior to the end of the current charter term. Charter oversight is intended to be proactive, and sometimes what we see are school districts focused on the charter petition for renewal itself, as opposed to the history over the past 5 years as to how that charter school has performed for its students, how it's performed financially, how it's performed governance-wise, and whether they have been a good charter school that has cooperated with the oversight, with district oversight. All of those things are supposed to be considered and renewed and are relatively easy to oversee over the 5-year period and should be considered at the time of renewal.
Yeah,
Right.
and revocation, which is the extremity of when a petition before it's up for renewal, there's something that's run amiss. I mean, something which is defined in law. It's best to have a little documentation prior to that, right? Think of your personnel situations. When you have a situation with an employee, what's the manager normally ask for is, well, can I see the evaluation? If there's not an evaluation, then you get the head scratch, right? So it really is a very critical part of oversight, is to keep up with the going-ons of the charter schools that you've approved. Now, we know the oversight fee is 1%,
Right.
and it's not enough to cover a member of the staff to do that, and that's part
That's
of
right.
the handicap.
If I can just add one
Sure.
thing, I would say that revoking and revoking and not renewing a charter are difficult enough. So make your life easy and have that proactive oversight and that documentation that Keith is talking about. Otherwise, it just makes it much more difficult. As Sue Ann had talked about, the legislature had added in its, for good or for bad, a few years ago, the discussion about increases in academic achievement being the most important factor before you revoke or don't renew a charter. Charter schools are very smart and have developed very sophisticated legal theories as to what that's supposed to look like. And they have stopped revocations, they have stopped non-renewals because of that provision in the legislature. So doing either is very difficult. Not to renew or to revoke is very difficult. So it should be something that should be made easier by proactive oversight.
That's right.
So I'd like to finish. We've got about 5 minutes left. This is all of the approval of the petition, and I think I started with too lengthy of comments in my view, but about the notion of autonomy of charter schools. And if you're a micromanager, which we don't encourage our board members to be, approving a charter school is not going to help out. Not going to help out that. So, local control. How do we oversee charter schools? Geographic limitations. We really have the privilege of the law firm that brought represented Anderson Union High School District in its case versus the Shasta Secondary Charter School up in Reading. Lozano Smith represented the district, and we were fortunate enough to hire Sue Ann Salmon Evans' firm, Dennis Wallaber Kelly, to do the amicus brief on behalf of the CSBA and its Education Legal Alliance. So let's talk about that case. A quote that comes out of the case is that the decision was that the decision is going to clarify a district's sovereign entity over public education within its boundaries. Period. What were the facts in the case, and then what did the case hold?
Well, the facts in Anderson, where you had a non-classroom based charter school that operated a resource center, what we'll call a resource center. There was a lot of what we argued was a lot of direct instruction, but it was called a resource center because it qualified funding-wise for non-classroom based as a non-classroom based program. They were operating that the Shasta Home Charter School in its home district as well as in Anderson, which was a district that was in the county. And the theory of the charter school and the charter community basically was that non-classroom based resource centers have no geographic restrictions on them. That the geographic restrictions listed in the Charter Schools Act of locating outside of the chartering district is supposed to be a rarity. That does not apply to resource centers. In fact, they were going so far as to claim if we wanted to set up, since there are no restrictions, if we wanted to set up a resource center in every district in the home county where the charter is authorized, we could do so. Now, that's how that case goes right to oversight, because I don't understand how a small district, school district that charters a charter school that suddenly starts setting up resource centers in, say, 10 different locations in the county, if they can do that, is supposed to provide oversight. So the court recognized that it does go right to the heart of the Charter Schools Act and the ability for school districts to be able to provide oversight. It gives charter schools legitimacy if school districts can provide oversight.
And the legislature had made an exception to the location outside of the district boundaries by permitting, in some instances, independent study.
May have one resource center in an adjacent county. What I thought was great about the decision is that this is an issue that has been pushed back for years now, but they focused on what they called the plain language of the statute to find that no, you can locate inside the district that authorized you. That's required by 47605, and you can have this one resource center outside in an adjacent county, but that middle territory is not allowed. And it does go back to the sovereignty of districts.
So we're clear, seat-based, when you have instruction where students are in a classroom setting more than 80% of the time, what are the rules around the seat-based and locating outside of your own district boundaries?
Well, it is supposed to be a rarity that happens. It is the exception to the rule. There are two instances that you can do that. And one is where you cannot find a location to house the whole charter school in one facility within the authorizing district. The second exception is where you are temporarily locating outside the district for purposes of construction or the light modernization. What we've seen, though, and to obtain those exceptions, you have to take certain steps. You do have to give notice to the local district where you're going to be locating. You have to give notice to the county and to the state superintendents. But what we do see is very small districts that are physically small, that do not have facilities, going ahead and authorizing, using this exception as the rule, and saying, we'll authorize you and you can locate wherever you want to locate, and be sure and pay us fees. And in a case that we brought on behalf of Newhall School District, the court did find that the district in that case was using it as a revenue generating scheme. So that's what we're looking for.
Right,
yeah.
Another bill that was vetoed by Governor Brown was that it passed the legislature that if you are in negative status, budget status, you can't approve a charter school. It was vetoed because that is a way that some districts, unfortunately, have seen as a way of getting out of that. Okay, so we have this decision about really the sanctity of the borders, of your boundaries, and you can only locate with some exceptions. Well, we know that there are charter schools that are up and running today, whether in meeting spaces or conferences or resource centers, whatever they want to call them, outside of, inside their own county. What's happening there? What do we anticipate is going to be the response to the Anderson decision? Because, as we know, the Supreme Court didn't take the case,
That's right?
So Anderson's law?
We know, yes, Anderson's law. What's happening now is that charter schools that have locations outside the district and in violation of Anderson some are working with their authorizers to seek a waiver from the State Board of Education. That's getting a lot of attention right now. We expect the board to take up that issue in May. I think there are a number of objections that they'll hear to that kind of an approach. Another option that charters are looking at is submitting the petition to the district where they're located and just try and get right with the law that way.
Any final comments from both of you? Thank you, obviously, for departing your wisdom to our viewers today. I'll give you a final comment about what board members should be doing to really get a handle on the charter approval process.
If you are considering a charter school, you're going to adopt a charter school petition, give your staff the opportunity and the resources to provide that proactive oversight.
I completely agree with that. And also have an open mind about the petition process itself. Think about what the charter is that's coming before you, rather than kind of coming to it with yes charter, no charter, that kind of thing. And really delve into what is going to come of this kind of a charter.
Thank you, Sue Ann. Thank you, Ed. We want to also thank our viewers for spending the last hour with us, as well as our presenters for your valuable insights. Ed and Sue Ann, we thank you for your firm's ongoing partnership with CSBA as business affiliates and for your contribution to today's discussion. Finally, this production would not be possible without the hard work of CSBA's communications, IT, business affiliate, and legal teams. If you missed any part of this webcast or would like to tell a colleague about it, it will be available on our website tomorrow at csba.org. You may contact our presenters if you have any questions via their email addresses that will be posted here in just a minute. Also, you will be receiving a survey via email. CSBA would appreciate your feedback on our presentation, as well as any suggestions you might have for topics for future webcast presentations. So please make sure to take a few minutes to let us know how we did. And thanks again for joining us today.